Yes, welcome to the No State Project here on my YouTube channel. It is, of course, Wednesday, episode 66, which means we are streaming live video HD here on No State Project on my YouTube channel, live from the Fortified Compound in Mesa, Arizona. And glad to be with you here for May 23rd, 2018, brought to you again by the benevolence of great guys, New Hampshire, of course, Bill, formerly of the Twin Mountain Country Store, who was just ripped off by people like George Kapatis, people who admittedly don't have a shred of evidence to support their claims about jurisdiction, and shamelessly and viciously attack anyway. But Bill's a good guy. I do appreciate the support of the show. If you'd like to be able to help support the show, it is at markstevens.net, and I do appreciate that. So let's talk about, we'll take calls today on the big broadcast. It is 218-632-9399, 218-632-9399. The passcode, of course, is 2020 with the pound sign. And I can also get into Skype. It's Frank Rizzo 3. Frank Rizzo with the number 3 gets you into Skype. Do not call. Instant message me first. Did I get a haircut? Glad you think I'm looking good. No. It's just a little water. I do need to get a haircut, though. So eventually I will have some time set aside in the day to go and do that, but not today. I want to thank everybody. We have I blew past 11K subscribers there on the YouTube channel. So, hey, do appreciate that. And, you know, I know there's a lot bigger channels out there, but my original channel got taken down by mistake. And so we've been building it. And I'm not a populist. I certainly don't say things that the average person wants to hear. But we do have a seriously good track record for getting tickets thrown out. And I got another one today. Ali has had seatbelt charges. Yeah, I know. It's not. It's still charges thrown out. And so I'm hoping they're going to be able to call the show today to give us the details. But what I have is that, yes, it is traffic code violation, where malum prohibita, just like a tax charge or a drug charge. So, you know, you can't, you know. So anybody who's going to piss and moan about that, yes, it's a traffic, but same challenges are made, which we'll go through. And it's more evidence to show that people have replicated the success by filing a motion to dismiss, the discovery request, and basically holding the prosecution to the burden of proof. Always hammering away at that and not accepting this garbage. Well, the prosecutor doesn't need evidence. That's just you know, that's just BS. That is the refuge of the incompetent, the criminals. Criminals are the ones that no, take my word on faith. I don't need evidence. Anyone who says that they don't need evidence to support their claims is a criminal. So yeah. So big congratulations to Ali. Hopefully they're able to call. I do have now the documentation for Ron's success story in Vegas, not traffic, by the way. So yeah, and Ron went through the same thing, continually holding the prosecution's feet to the fire, refusing to accept this garbage that police officers can make and prosecutors can make claims about you, and they don't have to support it. Again, that is evidence. Direct evidence proving corruption, dishonesty, and unfairness. Again, those who are honest don't make claims and say they don't need evidence. Oh, the rules don't apply to me. So take that for what it is. So to quote what I've said so many times here on the big show, you know, it's that which can be asserted without evidence can be dismissed without evidence. That's Hitchens' razor, and that's a pretty damn good way to be. It's called being a skeptic. It's being normal. It's actually using the brain, logic, reason. Which leads me to a persistent myth that I have wanted to talk about again here. This is something that comes out because people tend to get triggered when I say that they believe in faith, that the laws apply as a matter of faith, that according to them, no evidence is necessary. All you have to do is look at the law, and that proves that the law applies. Well, that's an issue of faith. That's circular logic, and that the laws apply because somebody wrote it down. That's not how it works. Again, basic principles of logic. And so some people have gotten, upset. Well, let's just say that they've criticized that. Well, we're not saying it's magical. So what they want to do is they want to make an argument. I don't know. Is it really an argument? I think it's just a baseless claim. It's not really an argument because there's not much. There's no propositions leading to a conclusion. So it's not technically an argument. So what they say is, well, we're not saying that the laws apply because they're magical. We're saying that the government, the people call government, and why the laws apply is because the government, they're agents of the people. They're public servants, and that the laws are just an expression of society. Yeah, this is actually a claim that's made, presumably with a straight face. We've had people make this claim on the show. So when you ask for evidence proving the laws apply, for those in the camp that believe that, well, yeah, there should be evidence. For those, they will go and they'll try to give this claim. Well, the Constitution and laws are expression of the will of the people, Mark. And if you weren't an idiot, you would understand that and you would accept that. The problem is, again, that which can be asserted without evidence can be dismissed without evidence. And here, the evidence is absolutely overwhelming against the claim that people called government are agents of the people. And I'm talking in a general sense, the way things are supposed to operate. We can excuse all the abuse above and beyond what they're supposed to do, protecting life, liberty, and property. So even taking all the abuse of discretion and all the abuse and misconduct out of the picture, the evidence is definitely stacked against them. And I've mentioned this, I don't know how many times on the show, but it's a very persistent myth. And it doesn't matter if you're in the United States or if you're in Canada or if you're in Australia, mate. It's all the same thing here. The evidence is there are men and women forcing us to give the money. So, used to be just pasty white European types, men. And now, government, at least in the United States, is an equal opportunity offender there, where they allow into the ruling class, the stooges for the ruling class. The automatons with guns, the useful idiots, as Comrade Vladimir said, that I'm not a communist. I'm trying to be funny. The useful idiots, there. Anyway, the point is that the evidence is stacked against you, and that they're forcing perfect strangers to give the money, and that's criminal. That is immoral. Well, you can't make a moral claim. Yeah, well, we don't have. I'm on a radio. I'm doing a show, but this forms the basis and how we destroy the myth. This idea that on the one side they want, well, it's just an expression of the will of the people. Where's your evidence for that? Here, the evidence is dead set against that. That's why I've asked bureaucrats. Yes, they're tools. They're just tools that are when their usefulness is over, they're cast aside. Those are the ones like Dennis Hastert that wind up going to prison. So this is why I confront them on that. If I was to do things the way your organization did it, and I was to force perfect strangers to give me money, would you consider me a criminal? And of course, they would consider me a criminal. And so thinking people, we don't accept this trash, this fallacious double standard that doesn't apply to these special people. So those who want to go and they want to put out this persistent myth that people called government are somehow different and that the rules don't apply to them, that they are just benevolent protectors of life, liberty, and property. And the means of government is consistent with government's end. They are deluded. You are wrong. You are absolutely ignoring the facts. But hey, that's what you do when you're a politician. That's what you do as a bureaucrat. And that's what you do as a lawyer who is shilling and basically an apologist for a gang of killers, thieves, and liars. And that is why none of the critics that you'll see on markstevens.net or on my YouTube stream here, none of them can make a rational, lucid argument for the validity of government. That's why. You could turn around and you can say, well, that's just the way it is. It's the way it's done. That doesn't change how immoral it is. There are some countries where there is still child marriages is like 6, 7 years old, or there's mutilation of little baby girls, genital mutilation. Well, that's just the way it is. That's wrong. Okay. That is dead wrong. That is horrific. And so we are going to apply that same principle here. It is an appeal to tradition to say, well, we've always had government, but that doesn't make it any less immoral. And that's not an argument in favor and showing that's a legitimate organization. So anyone arguing this myth that, well, you know, the government is just expressing the will of the people. No, you mean the same people that are forced by those same laws to pay and support and comply on the threat of jail? Hey, we got someone from Israel. Shalom. Thanks for tuning in. Yeah, this is, it is something that, and I know that there'll be a slur that we're just spooners. But, you know, I don't really take that as a slur. It's meant that way, but I don't take it that way. See, when the man's reason and logic is absolutely spot on, and his view of the evidence that there has never been a government by consent, unless by consent you mean at the point of bayonet. So you can try to slur, sorry, so you can use spooner as an insult, but you're still not making a moral argument for government. And if you can't make a moral argument for government, if they are literally just men and women forcing us to pay them, and they're a criminal organization, there's no logic behind any argument that you can come up with that show that their special laws, their sacred writ, their laws, their constitutions, which are just damn pieces of paper, written instruments, there's no evidence for it. So you can argue and say that I'm a scammer and say that, well, none of the judges agree with Mark. You can say that, and it's not actually true. But even if the individuals who carry out these crimes, that carry out these unfair, sham trials, even if none of them agreed, that doesn't mean that we're wrong and that the evidence is wrong and that the logic is faulty and fallacious. No, all that means is that it's like saying, well, Mark, find me one member of the Gambino family that agrees that with you that they're actually a criminal organization. Find one of the organization. Really? I mean, come on. But that is not actually true, that no one has, that no judge has agreed and nobody's had success. This is another persistent lie that a very handful of zealots will continue spewing. And I want to bring everyone's attention back to Helen in England, which I hope she's doing all right. I know anyway, Helen not only got a dismissal by challenging the prosecutor's claims that the Constitution, the laws apply, because she was physically in England. This is one of the benefits when you get the case management, when it's like a pretrial when you're in England or Canada or Australia. through that case management and really holding the prosecution to their burden, which includes, of course, supporting their claim that the laws apply and that there's jurisdiction and that the laws apply, and if a personam jurisdiction, that the laws apply to support their claim that you violated the law. So she not only was able to get the charges thrown out in writing. And again, her entire defense was what I talk about here on the show all the time. Every single show. Challenge the prosecution's claims. Challenge their assertions that the laws apply and that there is and that you violated them. That's all we do. She got damages awarded against the prosecutor's office. Now, whether she got those or cashed the check or received the check in the first place, whether she got that is immaterial. The fact that she got it, it's in writing that it was thrown out and costs were awarded here, her damages. So if you go to markstevens.net, and you've seen the videos, and I'm saying that there are success stories. There's a lot of success stories that are posted there. Helen's information is posted there. You got to go back a few years for that. That is what we call direct evidence, which we have also, in addition to that, a lot of circumstantial evidence with each dismissal to show why I'm saying that the most likely explanation with the circumstantial is that it was our defense. So take it with a grain of salt. I'm glad if you're, if you're at my website, it is a pretty good chance you're here or you're watching the show, because you're not a lawyer or a statist who just accepts what government says is the gospel truth. Well, Romans 13, Mark, I have to, if they're of the Christian type. So just investigate, take a look at what the evidence says. And in Helen's case, we have direct evidence, and that was in England, I think it was Sussex, direct evidence that just challenging this myth that the laws apply just because they say so, or the laws apply because it's an expression of society. Challenging that myth and demanding that they be held to their burden of proof has been very successful, and will continue to be successful, no matter how many people rant on my website or on YouTube. We're going to continue being successful. We're going to continue getting these things thrown out, whether you like it or not. Because more people, we're up to 11K subs, more people are subscribing and fighting these people. And hopefully we're going to get more people that are going to be challenging these people, not necessarily just with tickets, but are also challenging them in City Hall with their city council meetings, which I highly recommend, especially if you are prepping for court. What a better way to prep for going into these places, as bad as they are, as corrupt and dishonest as they are, and confront them directly on the issue of whether there's evidence proving their laws apply. Because when you got them in a city council meeting, I've done this before. They don't turn around and say, well, the laws are an expression of the people, Mark. They've never said that. They've never said, we've got lots of prisons. They've never said that. They've never said, similar to that, well, the evidence that the laws apply to you, Mark, is what happens if they prosecute you. So it's after the fact. Never trying to prove right here in the moment. The lone exception for out of court, which was a pretty big one, of course, I keep going back to that, Scott Bales of the Arizona Supreme Court, the Chief Justice there. Yeah, the laws apply because we put people in prison. So that's something like Al Capone's people. Well, let me tell you something. Al is going to sell his beer to you, and you are obligated to buy his beer. Really? Why is that? Well, things happen. You might not think you're obligated to buy Al's beer now. Okay? But I'm telling you right now, if your building is blown up, or let's say you fall against my fist a few times, that will prove that you were obligated the whole time. See, what happens after you don't comply, that's what's going to prove that. See, those are not the things that you hear at city council. What you hear at the city council is something sort of, oh yeah. Anything else? Do you have anything else for us? We don't answer questions, right? what you'll hear is, yeah, somebody knows. He didn't say the laws apply because we said so. In response to the question, he was saying that the laws apply in this jurisdiction. He said, yeah, we have jurisdiction because we said so, and then it's up to you to prove that that's not true. Well, that's easy to do. You didn't give any evidence to support your claim. Your argument is fallacious. You're just making a claim. It's a proof by assertion. It's not true because you say so. That's the way logic works. That's the way normal, rational adults work. Just saying something doesn't make it true. Okay? So, yeah, that was Colby Granville. So I'm glad that people are remembering that episode. So if you haven't seen that, I definitely recommend going to markstevens.net, doing a search for Tempe City Council, and you can see that video. It's not the best video, but it's pretty clear, and the audio is pretty clear. So it was going back 3 or 4 years. So yeah, still a good one. Not a shred of evidence. So again, then this thing that's well-settled law, that they can even kidnap you in order to acquire subject matter jurisdiction. Well, now you're making the case for me that it's nothing but a criminal enterprise. It's immoral. You really going to have the police officer testify on the stand that the reason why they acquired jurisdiction, that their whole basis of jurisdiction was because they kidnapped you, that they actually committed a felony? I'd like to actually see someone admit that in court. Yeah, it's yeah, they can kidnap you. Yeah. All right. No wonder you can't make a moral claim, a moral argument for government. No wonder you can't produce any evidence that their laws apply and give them jurisdiction, because it's literally based on violence. Thank you. So what you're doing is shilling for a criminal organization, which is what I've been saying. They are criminals. Oh, that's right. Yeah. Well, okay. I don't want. All right. So what I want to do, because we're starting to get lined up with calls over here, so I got to put these stupid headphones on. And what we're going to do is we're going to go to the calls. We've got Jeremy in Wyoming. Welcome back to the show, tough guy. Is he just listening? Okay. We will get back to Jeremy. I know he's been patient. But we have Will in Minnesota. Welcome back to the No State Project. What do you got for us today?
Oh, I got another one of these requests for missing income tax returns from 2014.
Really?
Yeah, we went through this before. I was on one of the Call of Shames with you a long time back when I was working. And I'm no longer working. I'm on a disability.
You want government disability?
Yeah.
Yeah, you can't make. You're not going to make it. You're not going to make a successful. You're not going to be able to successfully show they have no evidence in jurisdiction in that situation.
That's kind of what I was wondering.
I hate to be the one to yeah, and I hate to be the one to break it to you, but unlike a lawyer, I'm not willing to spin you a line of crap just to get money.
Yeah. That's what I figured. I wanted to know if I could call them and find out anything, because I don't have any idea where I'd even locate anything for 2014.
Well, you were working, so the company, it's only 4 years ago, so they may still have that information for you. I hate to be the bearer of bad news, but it's sort of like when people call and they're going through that, and like 2 years ago they filed bankruptcy. They're going to use it against you. So
yeah,
they'll say, well, we're not looking to really hit you hard, but we are going to say that you don't have any standing to challenge jurisdiction on this one, tough guy.
So I have to do whatever they want me to do. Then I don't know how I'm going to actually do that, but.
Well, I think, what you can do is you can get the information from the employer and do what you can. Again, it's only 4 years. Do what you can to get a return filed. Well, it's always under threat, duress, and coercion. Do what you can to get as many exemption or write-offs as you can, as much as you can write off. That's deduct. All right. anything that you
Yeah,
can, it'll be deductible.
yeah, there's another thing too, is because I'm exempt from a lot of things, not as far as like the taxes or whatever they're trying to say there, but anybody that was trying to file any kind of a civil suit against me, that they can't collect because of my status as being disabled.
Yeah, it being disabled, you can go through and file the return, and you can say, look, it's I'm on disability and it's uncollected. They could put you down as uncollectible, but they are going to want to, a full financial workup. So if there are any assets they think are yours, then they wouldn't put you as uncollectible until after or when they grab all that stuff. So if there's anything in your name that they are going to think is yours, that could be a problem for that. But that's the best that I can do for you in that situation. It really sucks, but you know what I've always said: if you go to and use the services of a whore, you gotta pay.
Yeah, because it just, that's what they forced me through. On as far as trying to get any kind of an income, they put me on a disability and started paying me that way.
Okay, well, that's again, try to get as many deductions as you can, and then show that it's uncollectible. So that's a very good real possibility if you're on disability. That's what'll happen.
Right. It's considered fixed income now.
Well, I'm sorry. Yeah, again, I wish I had more for you, tough guy, but I'm not a lawyer looking to get, have you be the source of my new car.
Yeah.
Yeah, it's probably the way. It's probably the way they look at it. They look at the house and they say, "Yeah, this is Jack, and he's paying my mortgage." And then one client, Bill, that's the Mercedes over here, but the Corvette, that's Sally. She's taking care of that. And my house in the Virgin Islands, that's a few people, and I think it's Bobby, Phil, and Joey. So that's the way I think. Again, I have no real evidence to support this other than lawyers tend to be vile, horrible scumbags. But I don't think they look at you and I as a bank account. That's why you get these jokes, which have a lot of truth to them, where the lawyer goes to the client, he's in jail. He says, look, I think we can continue this. I think we got a real shot to some newly discovered evidence that we just found. He says, really? What the heck? What? Where there was a bank account we weren't aware of. So.
All right. Well, thank you much for your help.
The best, what I can do there is I can recommend, if you want, I can recommend somebody that, who helps with that stuff, that may be able to help you get it as close to zero on with the deductions as possible. So you can email me about that if you want, and I can get you set up. And I'm sorry, let me know what happens with that. Hopefully it's something that, they can be deemed uncollectible and you can move on.
Right. I've got till the 14th of June, so I've got time.
Okay. Well, yeah, if you want, again, think about it. Contact me if you need somebody to help who specializes in that kind of stuff, because not me. And see what happens.
That I will do. And thank you once again for your time.
You're welcome. Will in Minnesota. Hate calls like that. It's like I work with somebody, and one of the first things I ask them, especially if it's taxes, are you in the tax court? And so somebody told me no. I said, okay, well, let's set up a consult. And 45 minutes into the consult, they start talking about court. Like, whoa, what court are you in? Well, we're in the tax court. I said, I deliberately asked you. So then I got stuck having to explain to this very nice woman that she's stuck. Well, can I withdraw? Yeah. It's an automatic judgment in favor of the IRS. And when you get a judgment from the tax court, it's permanent. Permanent. Technically not, but in practical terms, which is more important, in practical terms, you get a judgment from the tax court, it is permanent. You are not getting it overturned. Well, maybe if you have a lot of lawyers and a lot of money, but even then. He's back over here. We hopefully we get Jeremy on the line this time. Jeremy from Wyoming, welcome back to the show. We got you this time?
about that.
All right.
So just want to make it quick and brief, but I have court on Thursday, and I've got that writ of mandamus prepared, and it was really nice to look over it again as well with the just the court recording from last time I went to court on March 8th, because it was funny with this government, moral government that we talk about so much and joke about. She was like, when I asked that jurisdiction, she's like, "You're in Wyoming, you're in Sheridan County, you're in this courtroom, we have jurisdiction over you." I was like, oh, and it was just funny to hear that again, you know.
Did you challenge? I mean, did you ask her some questions based on, into if she can prove that that's actually, or why that's actually true? Well, why do you think my physical location here in Wyoming proves a written instrument, applies to me? Did you follow up with something like that?
Right. I did. I went through a couple of those same questions, and she just went to narrate the whole criminal proceedings and whatnot. And my mistake was not making any objections. I was just so blown away because I had planned out as much as I could and prepared as much as I could, and I just didn't expect that type of response. So I was blown away. But I was so thrown off that response was what I got, that I was just like, wow, okay, what do I do? But that's why the preparation is so crucial, I think.
Okay, but now for you and new people, remember, we always go under the assumption that they're lying through their teeth, right?
Right. And now I'm going to go in on Thursday and just object to pretty much everything like I heard on the last week's show.
But you need to still get into the role playing so the guys can help set you straight so that you don't get run over. You could still get run over, but at least you can get some really good appealable errors and also errors that you can use in a petition for post-conviction relief if that's the way it goes. So definitely prep so that you know how to respond. So if we know that everything that they say is a lie, or we're assuming that we're going to object and have them verify that what they're saying is true, we're going to do that through a leading question. So we'll do this every show if necessary because it's that important. Do you know what a leading question is?
Mm-hmm. The answer is in the question.
There you go, tough guy. So when they say something like that, you can say, so, all right, so just so I understand here correctly, your position is if I'm physically in Wyoming, this written instrument called the Constitution applies to me, and that's the basis of your jurisdiction. I was like, well, yeah. Now you just want to ask a leading question, or you want to ask a follow-up question, and it comes down to this. What actual proof do you have that that's true? Why do how does that work? Exactly how does my physical location make this written instrument apply to me? And that's usually enough to stump them because, look, unless you're an idiot, and I'm speaking legally here, you understand that physical location is not evidence that a written instrument applies to you. So that's where it stumps them. And that's why they'll keep going back to the code. And that's probably like what you were saying that she did, they go back to the code and just assume the code applies and then tell you what it says. It's just like an example that I give. If someone says that the Japanese tax laws apply to me, the stupid thing to do, or the ineffective thing to do, would just be to start arguing. Well, show me where in the law that's true. Show me, where does it say that? No. You're skipping the most important step. Do you have any actual evidence that the Japanese tax laws apply to me? Now, of course, the critics will turn around and they'll say, that's ridiculous, Mark. Of course the laws apply to you. The laws apply because they say so. But we're not accepting that kind of trash. So get them to verify. Get them to on Thursday, if they're going to make that claim and say that the written. Now, remember, if they're going to dispute the Constitution as a written instrument, that is significant. And I want you to tell me why that's significant.
Right. And I got those same answers too. Like when I asked another question, I was like, so it's your, blah, 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 the Constitution applies to me, that question. And she's like, yes. She got a little bit upset. And that's why it's crazy that, you're right. They had to go to the petition of written mandamus because she kept on denying motion after motion, just ignoring it, denying it, whatever you want to call it.
Yeah.
Whatever she wants to call it, because I never got any responses back. So that's why I'm really actually believing in this written mandamus because there's there's so much evidence in the written mandamus itself. And then that other motion that I was talking to you about last night is I just got to finish that up tonight, and then, get with the court again on either today, early tomorrow morning, and just send it all off, and then go to the court and say, the petition for written mandamus is pending.
Okay, but
so,
Jeremy,
you can do what you want to have. Yes, that
you didn't. You see, you're doing now what politicians do. You didn't answer my question. What is
I didn't hear you.
What is so significant if they disagree with your characterization of the Constitution being a written instrument? Why is that significant?
Because that's what needs to come first, if what I understand what you're asking.
Yeah, but it is very important. But the significance of them disagreeing that it's a written instrument is because now they're making a factual dispute. And the purpose of the trial is to resolve factual disputes. So if they want to dispute that the Constitution is not a written instrument or is somehow more than a written instrument, now we've got a factual dispute. And that has to be hashed out. Oh, and guess what? If they're making a factual dispute that the Constitution, which the cop says applies, and they're saying it's not just a written instrument, well, guess what? The police officer is the one who made the original claim. And on cross-examination, now he has to tell you factually exactly what is the Constitution that you say applies to me. Now, that doesn't call for a legal conclusion. That's not talking about constitutionality. That's not even saying that the Constitution applies to you on the stand. You're asking him what it literally is, factually. What is it? Use your power of reason and observation. You said this applied to me. What is it? So that's why it's significant. And anytime you've got a factual dispute, that's something that has to be hashed out in the trial. And if they don't allow you to hash that out in the trial, that is denial of a fair trial. They are going to be arguing and making a factual dispute, and you're not able, and you're not able to hold them accountable for it. You're not able to challenge them on it. These people think that this written instrument, which that's literally what it is, they think it's more, but they don't want to disclose to me what more actually means. And saying it's the Constitution is only telling me what is on it. It doesn't tell me anything that it's anything factual beyond what it actually is or what we know what it is. So they're saying it's more. Excuse me. They're saying it's more than just a written instrument. We want to know what they mean by more. And that is something, if they're going to be making those claims, you have an opportunity to confront them and question them on the evidence and the facts so that we can have a proper understanding. We can establish exactly what it is. I'm the prosecutor, and I'm saying that the Constitution is not just a written instrument. Okay, great. What do you think it is there, tough guy? What is it? Okay, so definitely, you definitely have to role play. You've got to role play. So I definitely get into the I don't know if you're in there or not. I think you are. Spend some time at least today with the guys, and at least an hour or so, and do some role playing. Hold them to their burden of proof. Keep them on point. When they don't answer a question, object, and then get an answer to the question. Because bottom line, people will say to you, well, they're not there to just answer your, they are supposed to inform you of whatever is being used against you. And the basis of due process, the foundation, the bare minimum is notice and opportunity to defend. And you cannot defend against something they're not disclosing to you. So don't listen to that crap. Okay.
Okay. Well, thank you for your time, Mark.
Well, I appreciate, hey, let us know what happened. Do the role playing and let us know what happened. All right.
Will do. Great. Thanks, Mark.
Appreciate the call. Good luck. Hope we got good news from Jeremy. I'm hoping that petition for writ of mandamus negates the trial and that they have to cancel the trial, but it's really coming down to it. So nothing may come of the petition for writ of mandamus. And we do that to stop the trial court. And we always file with we want to stay the proceedings in the trial court. So, he's been on the show before today. We've got Ted in Washington. Welcome back to the big show. You've got good news for me.
No, this is Doug from Washington. I did get your written reconsider. I just would like if you can take a look at prosecutor's rebuttal and give me a pointer as what to leave out or all that. Because I was questioning about Rule 16. I read it over the rebuttal multiple times. I do not see anything about jurisdiction of trial issue. So maybe if I can send it over to you and you can give me a yes or a no to some things.
Well, yeah, sir. A scan is sent to me, and I can certainly do a much better job. Based on my experience, prosecutors may not say in their response to the motion to dismiss that jurisdiction is a trial issue only, because if they did that, then there's a slight chance that a judge or the bar association would hold them for a ethical violation for mischaracterizing the law. It is not a trial issue only, and only the dishonest or the ignorant would make that claim. What they'll usually do is say he's in Washington, and in the statute says if he's in Washington, then the laws, then there's jurisdiction. But that is, of course, as we know, assuming that the laws or the Constitution applies in the first place. Because if there's no evidence the Constitution applies, there's no relevance to the statute. That's
right.
And only anybody with half a brain cell in their head would agree with that. The Constitution has to apply before there's any applicability of the code, because it's the supreme law of the land, and it's supposed to ostensibly the authority for the code. So let's go step one. Let's use logic. Prove your Constitution applies, then you've got standing to argue what the code actually says. But until that point, it's completely irrelevant.
Yeah, he starts off saying the motion to dismiss for lack of evidence of jurisdiction was gobbledygook, and then he starts stating the code applies because the code applies.
So that's right. So looking for evidence to support the claim, gobbledygook. But if you just say the code applies, and if you use a circular argument, the code applies because the code applies, or the laws apply because the laws say they, then you deserve to be the honorable, Okay, but we see through that stupid double standard. But yeah, send me a copy. I'd like to see that, and I'll let you know what I think and how to respond to that. Basically, what it comes down to is what I already said. I'm sorry?
I'll say just a quick response to, what you can tell me to take out or add in.
Yeah, you're going to basically just point out that the prosecutor is he's ignoring the actual issue, and he's responding to something else as if that was the issue. So he's kind of straw manning, and then he's also using a circular argument. He's also lying, and he's misrepresenting the motion to dismiss by saying it's gobbledygook. It's very easy to understand. You don't have any effing evidence to support your allegation. That's not gobbledygook. At least now I get to put that in the video again. Gobbledygook. I'm doing, I think we got some pretty high marks for that atrocious editing that I did. So,
and that was the basis of the motions hearings, denial.
It was gobbledygook.
Yeah, pretty much silently. Just sided with the prosecutor because he didn't want to deal with it.
Yeah, that's kind of typical. Don't look at this critically. Don't actually be a fair, impartial, independent decision maker. Let's not even put up a pretense. Okay, let's not even pretend. I am here to help the prosecution because we're just putting on a show anyway. Everybody is guilty. There's no fairness, and so that's what they do. So send me a copy of that, and I'll get back with you as soon as possible, and hopefully we got a good resolution to that one.
But the RCW applies because the RCW applies.
Yeah, I love that I had a prosecutor up in Washington. When I asked him, I was like, "Why exactly does the Constitution and laws apply?" Because I'm physically in Washington. It just does. Wow. Really?
Wow. That sounds good. You've been here. Okay.
Yeah, it's brilliant. We'll definitely do some role playing, and we'll discuss more off air. All right, appreciate the call, Ted in Washington. Running low on time over here, but we got some more calls. I'll do my best to get to everybody here. But we got a new caller, which is always great. Your area code 615. What's your name? Where you calling from?
Hi there, Mark. This is Jenny and Ollie out of Nashville, Tennessee, calling to report a Mark Stevens win for the day.
Nice. I'm sorry. And where are you calling from, Jenny?
Nashville, Tennessee.
I'm just going to say Tennessee.
That'll work. Tennessee works.
Well, give us some of the details.
Well, we went to visit the tax collector today, and
Okay.
we went to visit the tax collector today, and there wasn't even a judge in the room when we got there. She was inviting the people up to plea without a judge. We, however, did not do that. When we were able to make our appearance, they seemed to be a little frustrated. And they had moved our court case without us knowing, and I asked her if she gave us proper service, and she said, we told you we moved the court case. And I said, no, ma'am, I have to have proper service, and I'm ready to proceed today. So I'll let my husband tell you the rest of what happened, but inevitably the case was what's called nullified, which I've never heard before.
So, Mark, this is Ali. Hi, Mark. Hello. Mark.
I did it again. What led to the nullification now?
Okay, Mark, this is Ali. So I'm going to talk real slow. So what our ticket was, seat belt laws, like me and my wife were driving in a car, and he gave us 2 tickets, and they put us like charge partners. So they put us together, and he gave us a court date for today. And about a week ago, I filed a notice and demand of definite statement of allegation of bona fide jurisdiction. So I asked them, tell me, what is your jurisdiction?
You asked them what their jurisdiction is. You didn't say what evidence you have to show that your laws apply because I'm in Tennessee.
No. Yes, I said I wanted them to allege the jurisdiction, and when you allege, I'm going to challenge it.
Okay.
And I'm not going to challenge anything if I don't know what it is. So I filed that notice and served them in DA's office, because it was a Tennessee versus us, not like a Metro Police. It was the state of Tennessee. And without any notice, when we went there, they said, your new court date is June the 6th. I said, nobody notified us. We didn't know what's going on. And they said, this is not a real court. And we never heard this. It is settlement court. So settlement docket. So what kind of settlement is this when plaintiff is not there, when the officer is not there, right?
Well, you actually don't need the police officer there if you're going to settle with the prosecutor. So most of the time, the prosecutor is the only one involved in the pretrial process. So when you go to arraignment and pretrial, the police officer typically won't be there and doesn't need to be there for most situations.
Yes, but the prosecutor was missing too. And we said, nobody served us. Oh, we've been sending you letters and everything. I said, no, you need to show us the proof of service. We didn't get anything from you. We supposed to be here today, and you need to call the prosecutor. And they said, no, we cannot call prosecutor. We give you a new court date, whatever. I said, no, we are here. We want to take care of it today. So it took about 30 minutes. And the prosecutor showed up. And at the same time, when we entered the courtroom, there were about 25 people. And what they were doing, giving somebody, there was a lady, she was collecting their money, or asking them, you plead guilty, not guilty, pay the fine, go to school, whatever. And what they did, they get rid of everybody in the courtroom. So only me and my wife left. And the prosecutor came and he said, we want, I didn't subpoena the officer. So what we can do, can we move to June the 7th at 9 a.m.? I said, why? What you want to accomplish? And judge even asked, what you want to accomplish? I said, I would like to dismiss the case. And judge said, why you want to dismiss the case on 7th? I just don't want to dismiss today. I want to do 7th. Judge said, I'll just move forward to dismiss it today. So he said, okay, I'll take my case back.
So the judge wanted to dismiss then and there. The prosecutor didn't want to dismiss for some unknown reason until the 7th. And so the judge was going to dismiss it anyway. And so the prosecutor said he's going to take it back. And the judge allowed that?
Yes.
Okay. And the judge allowed him to...
Yes. If your intention to take it back, why not today? Why you going to waste everybody's time?
Sure.
So, excuse my language. The attorney, the state attorney, looked like a really upset and he was looked like somebody raped.
I didn't catch it. He looked like what?
Somebody just got raped.
Okay.
That's his face expression was. He was really upset. And my only notice, and we have our motion to dismiss and everything ready, but we thought it's going to be really hard, but state did not want to pursue the case. They just wanted to let it go.
So they eventually so they have a nolo prosequi, which is a no prosecution, where the prosecution withdraws and declines to prosecute. So that's that, so to having it nullified, I mean, that may be a little different than that. So who actually said it was nullified? Was it the judge?
The prosecutor, he said, I am going to nullify the case. I'm taking it back. It's nullified. We are not going to go to trial.
Nice.
And that copy of demand of bona fide allegation of bona fide jurisdiction, I think I emailed you the copy too. And this is notice. And they did not want to answer that. The notice about you allege the jurisdiction, tell me what jurisdiction you have, then I'm going to challenge. And I cannot challenge. I don't know what you have. I only have your pink copy. You cited us for not wearing seatbelt. And that does not disclose any jurisdiction. When you disclose it, then we're going to challenge it.
Well, good job. Congratulations. Did you get this nullification? Did you get that in writing?
No, it's on a video. On a recording, and we are going to make a copy of that, and we send it, and we are going to contact Court Clerk tomorrow if they give us something in writing.
You should be able to get it in writing. You can check tonight if the court is, because lots of courts now have the docket online, and if it was, when something is dismissed, it will be on the docket. Now they may not have updated it yet, but it may be available. So if it's not available today, then, or, they could be available tomorrow, but check with them first before going down.
Yes. And I will get a copy, and I will email you that copy of that there.
Yeah, that would be great. And I know the criticism could be, well, it was just a seatbelt ticket, but you were making the same challenge in jurisdiction you would in a more serious misdemeanor traffic case, or even a felony drug case. So, that's just a way of doing anything possible to negate. It's kind of like something that goes on in the White House. Well, if someone did something wrong, I didn't know about it, or if they did do, if he did do something wrong and he was part of my organization, then he was a very minor part of the organization. No one even knew his name. He just got caught. Just to anything to negate or diminish the significance of it. And but hey, I think there's always merit to standing up and challenging these predators. And so I think, congratulations for standing up to these predators and not take. I mean, you did good, because a lot of times I would imagine the judge would just say, "Sir, we're not here to discuss this. You have a new court date. We're done. And if you don't leave, we'll just have you arrested and removed." But here, to stand your ground that way and have them actually get the prosecutor, that kudos to you, my friend. That was great. And I appreciate you calling and let us know about it.
Awesome. We thank you here in Tennessee for all of your help, and we'll continue to fight tyranny.
Well, I hope you don't have any personal fights, but yes, if you can, I appreciate that. So if you can now take it to a city council and address the question of jurisdiction with them, and then also put the moral issue to them question that if you did things the way they did and force strangers to give you money, would they consider you a criminal, and see where it goes. I would definitely like, so if you're able to do that, that would be fantastic. But again, congratulations, and I appreciate the call.
Thank you so much.
You're welcome, and I'm looking forward to seeing the document that it was nullified. Nullified, because if they had proof to support their claim of jurisdiction, they would just present it. And just for those 2 or 3 people who disagree, or actually disagree in post, is your physical location sufficient to make a prima facie case to then create a rebuttable presumption? Remember, prima facie evidence. So you've got the fact that proves the claim. Does the single fact of your physical location in Tennessee, does it prove a written instrument called the Constitution applies to you? Is there any even the slightest chance? The answer is no. No, no, no. Impossible. And if someone disagrees with me, you have to tell me how your physical location, just your physical location, will prove a written instrument applied to you. You mean that written instrument that everybody is forced to comply with and pay for? Yeah, that one. Okay, we got a few minutes left. We're going to go to an old paisan over here. Mark in San Diego. Welcome back to the big show.
Hey, what's up there, brother? How you doing today?
I'm doing well. What you got for me today, paisan?
Oh, check this out, man. Okay, we got a supervising criminal division judge in Department 102 down here in his new courthouse. Now, that's all fine and dandy, except that he's been involved in some past stuff with me. And his wife, Honora L. Smith, the judge's name is Michael T. Smith, is a city attorney. How's that for a conflict of interest?
Wow.
I would say severe because she was involved at the onset of my case here. I, just got wind of this the other day, and I started asking around. I went up to the court clerk because I wanted to file a quorum nobis. I had to file that with the supervising criminal division judge, which is Michael T. Smith, and his wife was involved in the case at the onset of the case. So I'm like, how the hell am I going to get this heard, and how the hell am I going to get it heard fairly?
Well, the thing is, wait, let me jump in because I am really low on time and I can't go over too much on today's show.
All right.
The prosecutor was supposed to disclose immediately if she was assigned to a case her husband was assigned to. The husband should have on his seen who was assigned to that and immediately recused himself. So how long has this been going on without them recusing themselves?
Well, he wasn't directly assigned to the case. See, that's the thing. Now, I ran the thing through the appeals because I wanted to appeal the suppression motion that they withheld evidence on and hindered my suppression motion. But anyway, I had to appeal that motion, and they got me on timeliness. Well, whatever there. So I filed a quorum nobis, to point out all the prejudicial errors, such as the withholding of evidence. I found all the statutory provisions that hold them liable for that criminally. I also found the statutory provisions that hold them liable civilly. But that's pretty much in the Coram Nobis petition. And it's almost acts as if, this thing does get heard in the correct department, that there's an automatic bias created. Now, who besides him could hear it? The presiding judge?
Well, certainly the presiding judge, has administrative jurisdiction over the courts. And so when you have a situation where there may be a conflict of interest, then yes, the presiding judge is the one that would take care of that.
Well, that would kind of I think it may be helpful that it gets to him. See, Paula Rosenstein, she's trying to, because it was out of the jurisdiction of the trial court, we had to wait for the remediator from the appellate division to come down, and they don't get jurisdiction back until the 29th, when they want to see me back. And I forgot to tell them that their presumption of jurisdiction is rebuttable. It's not conclusive, and that you can use, evidence code 600 paragraph A, where it says a presumption is an assumption, and a presumption is not evidence. But besides all that, I'm trying to figure out, okay, now, to point out all the errors that they have made thus far to the presiding judge. Do you think that's
well, the error, as far as legal error, is not the presiding judge. That's something, unfortunately, the presiding judge can't interfere with a ruling unless it's, in my understanding, unless it is a motion to change the judge. Then the presiding judge can step in and make a decision there. But as far as determinations that are made on motions or whatnot, no, that would have to be done by the appellate court, which is where you could get it heard by a petition for writ of mandamus or a petition for writ of prohibition. So, but I'm pretty much out of time here, and so I do apologize. Other questions you can get with me off air, or you can call the Saturday broadcast, where I will be live Saturday. Think I am. If I'm not live, I'll let everybody know. If I'm not going to be live on Saturday, then I may be able to do a bonus stream, commercial free, right here on Friday. But I will let people know. And that's why it's important to be subbed, so that if I do the show on Friday, you will know about it. All right.
Hey, let me know whenever you're in San Diego again, too, man. I'd like to hook up with you.
I'm going to see what I can do about getting with the boys in Oceanside and doing the jam and doing the show. Hold on. Going back to Oceanside and doing a jam with Bill and the guys before they leave. So hopefully we can do that within the next month or so. And I'll post that up on markstevens.net, and you can hear it right here on the broadcast. So yeah, I'm looking forward to doing something like that, because a friend of mine got me a killer Fender all tube amp that this Les Paul there's a tube amp with EMGs in this Les Paul. Oh,
oh goodness.
Oh,
yeah, I can only imagine.
Yeah. Oh man, when I play the that second solo, the outro solo on LaGrange, yeah, it's nice. Pretty good.
Oh yeah, but it's
so
grindy.
Oh, it's some serious tone. But hey, it's a tube amp, so they did right with this one. It's only a 15 watt, but trust it goes. But I do have to go. But yeah, keep in touch and let me know what happens there. And when I'm able to get to Oceanside again, I will let everybody know.
Please do. All right, brother. You have a great day.
You too. Appreciate it. Mark in San Diego over there. I am totally out of time. Let me get that damn thing out. I do want to address something over here before I go, because people like to turn around and critics that it's my opinion that there's no chance that my physical location in Arizona would prove that a written instrument applies. It's not my opinion that there's no chance. You see, you notice those of you who say there's no chance don't actually try to spell out exactly how your physical location proves a written instrument applies. But basic principles of logic, of course, are always what are dictating here. People like to say, well, that's just your opinion, because they don't like my argument. Well, it's just your opinion. It's like saying punching your wife in the face is wrong. Well, that's morality, and that's just your opinion. Or killing babies. Oh, come on, Mark. That's your opinion. That's wrong. Don't you force your damn morality down my throat. A written instrument. We have basic principles and factual elements that must be there to prove that a written instrument applies to somebody. And the big one is a freely made agreement or consent. So there's an offer. There's a meeting of the minds. There's consent. So, this idea, it's just your opinion. Well, you can say the same thing if I say that Bill Clinton lied through his teeth. Let me make this perfectly clear. I did not have sexual relations with that woman, Miss Lewinsky. Is that my opinion? He lied through his teeth? No, the evidence showed he lied through his teeth. He admitted he lied. The evidence is what determined that. So it's not my opinion. And again, if you think that there's any chance that my physical location can prove that a written instrument nobody bothered to sign, called the Constitution, any chance that single fact can prove the proposition that written instrument applies to me, present the damn evidence. Show me how that is possible. Don't just say, that's your opinion, Mark. Show where it is just my opinion, because I'm going based on the lack of evidence. Oh, and by the way, it's your hero's opinion also, because when confronted on this broadcast, how exactly does my physical presence in Arizona prove a written instrument applies to me called the Constitution? He says it doesn't, because it's not possible. You have to have, again, 4 factual elements. 4. None of them are present there. So if you disagree, show me exactly how my physical presence proves a written instrument applies to me. Then it's not a matter of my opinion. If you can present that, it's not a matter of my opinion then. It's a matter of me just ignoring your proof, which I am pretty certain I am not one to do. So go ahead and do that, because that's just not going to happen. And bottom line, like I started to show, the reason why, the evidence that you and no one else can do away with, you can ignore it. Oh, the evidence is against you that they apply in the first place, which is why you cannot, under any circumstance, show that my physical presence proves that these sacred laws apply, because they're just men and women forcing strangers to give them money. They have always forced people to comply. They have always used violence and aggression to get people to pay and comply. They are criminals. So if you're going to shill, if you're going to be an apologist for a bunch of men and women whose arguments are so bad, they have to force compliance with them and kill us in the process of getting compliance, having a massive prison system. Oh gosh. Yeah. Okay. I'm going to have to end the broadcast here. Again, if you think I'm a liar, whatever. Oh my gosh. Someone on YouTube thinks that I'm lying. What should I do? Oh my gosh. I have people saying bad things about me on a YouTube stream. Again, you can go to an Iron Maiden. You can go to Live After Death, the video stream, and you'll have people doing things like that. So again, put up your proof. This is what kills me. Scott Bales is a Harvard Law graduate. He is the Chief Justice of the Arizona State Supreme Court. The best he could do to say that these laws apply is to say that other people were put in prison. But these people on YouTube, they think that they know better. And no, I'm not lying about Galt. He said it on the show. He then tried to back it up and say that a jurisdiction's a matter of force. So anyway, if you've got proof that these laws, these sacred laws apply to anybody, put it up. And again, that is, again, to address this criticism that it's my opinion only that these laws, that there's no chance that that the fact supports the proposition and then creates a rebuttable presumption. And the thing is, you can't. So, and that's the thing for everybody. If you're going into court, it's not a rebuttable presumption. In practice, it's an irrefutable presumption, and that's unfair. Again, my name is Mark Stevens. You're listening to the No State Project here on on my YouTube stream. The LRN stream will be on Saturday, but this has been for May 23rd, 2018, episode 66 of the big broadcast over here. I will get this up as soon as I can. Probably not today, maybe the audio, but definitely the video by tomorrow at markstevens.net. So till next time.